Hello and welcome to Lawchakra podcast. My name is Srishti, host for today's session. Today we are going to discuss about the new Information Technology Amendment Rules 2023 introduced on April 6 by the Ministry of Electronics and Information Technology. Via these rules, the ministry intends to regulate online intermediaries by introducing new obligations in digital media and online gaming sectors. However, it is suffering from issues like censorship and executive overreach. To understand these new rules in depth, we have a very special guest today, Ms. Sanya Arora. Sanya is an independent advocate practicing on the civil side in Delhi NCR. She is the founder of Lawchakra, legal training program to enable access to quality legal services and legal education. Welcome to the podcast, Sanya.
Thank you so much, Trishti. Thank you for having me and a great initiative. And I'm really glad to be here. Thank you for inviting me.
Thank you so much. Before we start, can you tell us about your inspiring journey to our audience?
It's still unfolding. It's not as inspiring as a lot many out there who are struggling and striving and making a name for themselves in the legal industry. I'm just one of those people, and what I try to do is just keep going on, keep moving on, and be better than I was yesterday in whatever I face, whatever challenges there are as a woman litigator, as a first generation lawyer. I just try to take them in my stride on a daily basis and not give up. I think that is what is important. Just not to accept defeat and just to keep going on. But other than that, I have done my law from Department of Law, Chandigarh, Punjab University. I graduated in 2018, and ever since I've been practicing on the civil side majorly, civil, commercial, family law matters, and information technology and intellectual property are the two domains that specifically intrigue me and interest me. The developments that are happening at such lightning speed that it's very difficult to keep up, but they are very interesting developments, and they, I believe, will one way or another shape the future of our economies, our political, social fabric. It's all in the process of rearrangement, and India is developing very, very fast, and it's very important to keep up. That's what we try to do.
Yeah, that's really interesting. Now, coming to the topic, do you think this new IT rules will really tackle fake news, or will it lead to breach of our fundamental right to freedom of speech?
Right, Shifty. That's a loaded question, I believe, and that is being contested, and it has already been challenged in Bombay High Court, if I'm not wrong. One writ petition has already been filed to challenge the constitutional validity of these new amendments. Before we go on to the concept of fake news and misleading news and information, I would just like to quickly give a brief background of how we came here. So, IT Act 2000 was enacted to regulate the rapidly changing internet digital world that we were inhabiting in. But after that, there were some regulations and rules that were introduced for intermediaries, for digital media ethics guidelines, that happened in 2011. Now, as per section 87 of the act, the parent act, the central government is at liberty to make rules and regulations under the act. Now, those rules and regulations are subordinate legislation. They derive their meaning, their existence, their significance from the parent act, which is the IT Act 2000. Now, those rules, 2011 rules, were amended again in 2021. And when those rules were amended, they were essentially looking to regulate intermediaries. Now, when we talk about intermediaries, they are these social media platforms and the OTT platforms, and what their liability can be if anything offensive, anything unbecoming, or anything morally corrupt, or anything that may be considered as a violation of freedom of speech, when it comes to the reasonable restrictions that are enshrined under Article 19(2) of our Constitution. So, if anything strikes at that, then it becomes the responsibility of the intermediaries to ensure that such material is taken down, or such accounts are blocked, or any other reasonable measures are taken to ensure that such a violation that is not within the scope of Article 19 that is a freedom of speech, and that creates incitement or hatred or a threat to the sovereignty of the state, then it becomes the responsibility of the intermediaries to ensure that that kind of material is not published or not disseminated amongst people. Now, that can happen only when intermediaries have actual knowledge of something like that being uploaded to their platforms or their websites or their digital presence that they have, because they are not regulating the content that is going on. And that issue was discussed in Shreya Singhal's case, which was a landmark judgment in 2015 by Division Bench, where the Supreme Court held that Section 66A, which talked about just sharing information that is believed to be fake or misleading or not true, or false for whatever reasons, or it is a controversial statement, if you're sharing that statement over social media platforms, then that was an offense under Section 66A of the IT Act 2000, and that was held to be unconstitutional by the Supreme Court, stating that it this particular section is void for vagueness. Now, void for vagueness is a principle of interpretation of statutes, which basically says that anything that is very wide or very generalized with no particular meaning or no particular definition can be misused, and anything that threatens the liberty of people in that way should not be allowed, because it can be misused by the state. Now, if we talk about material that is offensive, that is obscene, that is morally corrupt, that is fake news, that is false, that is very subjective, right? Until and unless it falls within the reasonable restrictions that have been enshrined under Article 19(2) of our Constitution, until and unless any of those 8 grounds are kicked into existence because of the material that was published or whatever else was said, freedom of speech cannot be restricted. It is settled law. And that is why Section 66A was also held unconstitutional. And when it came to Section 79 of the IT Act 2000, which talked about the safe harbor of intermediaries, basically giving them some relief from being responsible for all the content that was being published on their website, it was held by the Supreme Court that until and unless a court order or a government direction is directly given to the intermediaries that this particular content is falling afoul of Article 19(2) and is essentially restricted by Article 19(2), then they are liable to take it down within 24 hours or 36 hours of receiving that information. That is what it was meant by having actual knowledge of something being published which was not correct in the legal sense. So that happened in Shreya Singhal's case. Then after Shreya Singhal's case, 2021, new amendments came to the IT rules of regulating intermediary guidelines for digital media. Now, digital media also included the online newspaper websites that we have, news websites, and where they were publishing different articles of whatever was going on. So there were certain restrictions that were placed on the publishers as well, and there were more restrictions and more obligations on the intermediaries by 2021 rule. Now, in that, what happened was that the intermediaries were once again held to be taking reasonable measures to ensure that whatever is being published is not within the reasonable restrictions of Article 19(2). So that again became the responsibility of the intermediaries. And what had happened in Rule 9 of those rules was that the government said that what we will do is we will set up grievance appellate tribunals, which means that if there is an order that has been given to the intermediary to take down a material and the intermediary does not take it down, then that will be decided by these grievance appellate tribunals, which will, or committees, which will be formed by the government once again. So they were the overseeing or the supervisory authority to judge whether or not anything can go online or should be taken down or not. So that itself again was a strike at the freedom of speech and expression, because if the government is the ultimate arbiter of what can be said and what cannot be said, it's as good as, I don't know if you've read this novel by George Orwell, 1984. It's been talked about a lot. It's set up in this dystopian world where the government makes sure that everybody knows just one meaning for one word which is allowed by the government, and there is no other. So they have this language called newspeak, where no creativity or no interpretations of any words can be done by individuals unless it is allowed by the government, or it will cause thought crime. So basically there is this policing on people's thoughts, and that happens through government. So that's an extreme example where if the government in our day and age is allowed to decide what goes online and what is published and what is really uploaded or disseminated by people like you and I, then it will essentially mean that they will ultimately be the judge of what we are allowed to say, what we're not allowed to say, what we're allowed to express, what we're not allowed to express. So freedom of speech and expression is definitely threatened. That happened in 2021 rules, which were challenged in various high courts, and then the batch of petitions of those challenges were taken to Supreme Court. And in Supreme Court, all of those proceedings were pending while 2023 amendments came. So in the meanwhile, now they have introduced these new amendments to those amended rules, and in these amendments there is a specific provision that talks about fact checking units of government bodies. These fact checking units will have the only job of making sure that they are vetting everything that's online, making sure that there is no fake information or false information or misleading information against the government about any of its business. It actually uses any of its business, which is a very vague term again, that what business are they talking about. So if any information is published about any business of any government body, they'll have their specific fact checking units who will then decide whether that information should stay up there or should be taken down. In my opinion, it is violating the fundamental right to freedom of speech and expression, and that has already been challenged in Bombay High Court by Kunal Kamra, who's a very famous political satirist. And I do believe that many more such petitions will come up in different courts in different jurisdictions.
Yeah, that's really interesting. You were talking about that fact checking unit. Now, can you just elaborate, like, will this be really independent of the government, or if it's not, then how can we ensure a neutral position?
That exactly is what is under challenge. The fact that these checking units will be that particular government body's extended unit. For example, it can be Press Information Bureau. It relates to Ministry of Labor. It'll be one particular department from that particular ministry who will become a fact checking unit, making sure that nothing against that particular department is being said, which is false or misleading. So that itself is under challenge, because this is violation of the fundamental principle of natural justice, that you cannot be a judge in your own case. You cannot be a judge and a prosecutor in your own case. There is, so government is the largest litigator of our country, right? And whatever disputes or contentions are pending or may arise between citizens and the state, the judiciary has the right, and the judiciary has been given the responsibility to be the arbiter, to be the judge, to be independent. And that itself is being struck when we talk about these fact checking units. I would really recommend reading the petition that has been filed by Kunal Kamra. It's available online, where he has specifically said, his lawyers have specifically said that, for example, there is, somebody who's a political satirist, that is his main profession, and the way he shares his content is through social media, and his content is largely about making fun and making jokes on the government. If the government gets offended by it, because the rules are so widely worded, they're so vague, that they can easily be twisted into something that the fact checking units of that particular department will consider to be misleading or insightful or offensive, and they will take it down, and eventually they may even direct the intermediaries to block the account of such political satirists. Or that again strikes at Article 19G of the Constitution as well, which is freedom of trade, freedom of practicing any profession that you like. So that also gets challenged in a way if these fact checking units are not regulated by independent people, people who are not nominated, or people who are not designated, or people who are not deriving their salaries from the government.
Yeah, that's really interesting. Now, you're talking about the vague terms like fake or false or misleading, which will be used to describe content that will be subject to fact check. So, do we have any definition or clarity on this word still now?
So there is no definition of fake news, misleading news, offensive news. There is no specific definition of these terms, and that is why it becomes very subjective, and that is why it is prone to being abused and misused, because there is no specific definition. In fact, in Shreya Singhal's case, also this was one of the contentions, and this was held by Supreme Court, that if there is no particular definition of misleading information, there's no particular definition of what constitutes to be annoying, or being really offensive, then how can somebody be held guilty of committing those crimes, if they call it that? Then that crime that you're talking about has to be very well defined, which has not been defined. Again, the IT Act 2000, the Parent Act, does not foresee, does not stipulate for the government to be creating such fact checking units, or for the government to be supervising or overseeing or having grievance appellate tribunals. In fact, 2023 amendments were largely welcomed by the online gaming industry. So there were some regulations, some rules that were made to regulate the gaming industry also, which is a very booming industry, and it's projected to have around 1.9 billion revenues by the end of 2024. It's a very big industry, and to regulate it, these rules were initially introduced to include online gaming intermediaries, to include online gaming companies within the ambit of these rules. So when these rules were first introduced, when the proposed draft was uploaded on the official website of the ministry, and they invited comments by various stakeholders in the consultation process, there was no mention of any fact checking unit there. So at the end of that consultation process, they introduced the fact checking unit amendment. And then after that, they quickly closed the consultation process by the second week of February. In January 2023, these proposed amendments were uploaded for public to share their views on. And then by second week of February, I believe, they were closed. And by then, they had also set up grievance appellate committees. The government had already gone on to proceed with the rules, even though they had not been finalized, even though there was a lot of petitions pending before high courts and then also Supreme Court. So they went on to create a grievance appellate committee also, and they notified these rules in April 2023 with the fact checking unit amendments and everything else, despite despite a lot of backlash, despite a lot of challenges. And there were a lot of stakeholders who had recommended and who had given their views about changing these particular rules to be more independent, to be more neutral, to be more fair. But a majority of those comments were taken into account, and the eventual notified amendments were largely based on the draft that they had circulated in the beginning of the consultation period. So, yeah, there is no specific definition of what constitutes to be fake or misleading. We hear those words every now and then. We know that there are a lot of YouTube channels, there are a lot of articles that are about fake and misleading news. We don't know the source of where that information is coming from and everything. But that in itself does not entitle the government to restrict the speech, to restrict the expression if it's fake or misleading in a democratic polity that we are in. The best answer to speech is counter speech, and especially when it comes to the government. So if there is any such information that they believe to be false or fake or misleading, they can always release, they can always have a press release, they can always have a clarification, they can always say that, this is not true and you should check your sources. And they can always send warnings to those publishers. But to bring uh, such a hefty obligation on the intermediary to ensure that any such news that is deemed to be fake news by the fact checking unit of the government has to be taken down. That in itself is policing of thought, in itself is restricting freedom of expression. And it does not, I mean, I keep saying this again and again, but it does not fall under those 8 grounds that have been mentioned under Article 19.2, and it has been held again and again. It is well settled that anything that does not fall within the reasonable restrictions under Article 19.2 cannot be held to be a restriction on freedom of speech and expression. So that is a very big question on these rules. Another very big question is that when the Parent Act did not foresee something like that, can a subordinate legislation bring stipulations and provisions and rules and regulations in that regard without the Parent Act foreseeing something like that?
That's really interesting. Now, you were talking about that Shreya Singhal case on Section 66A. Now, after this rule, like, will this rule try to bypass those judgments and try to dictate its own terms in future?
I would want to be very careful in answering that unless, I am deemed to be inappropriate by the government. If we strictly talk about it legally, if we strictly talk about it in principle, then our constitutional protection that we have to our fundamental rights is very sacred to our nation, and it has been upheld time and again by the courts. Whenever the government has inadvertently or not deliberately overstepped or over broadened their reach, the courts have always tempered them down. The courts have always ensured that the constitutional fundamental rights are upheld. So yes, Shreya single judgment was a landmark judgment which talked about the changing facets of freedom of speech in the digital era that we live in. That had not been discussed at length and with such great depth before Shreya single case. And one way or another, these rules, especially with the fact checking unit and with the grievance appellate committee that has been created by the government, where the government gets to decide what stays on the internet and what doesn't, does seem to be skirting around the mandate that has been upheld in Shreya Singhal's case. And if so, there are plenty of remedies, there are plenty of ways for general public and for stakeholders and people who are affected by it to approach the courts, to knock on the doors of justice and to get justice.
It's really interesting. Now, I'm switching to the online gaming sector. Like, do you think these new rules will address the uncertainty around legality of online games, like betting or gambling in different Indian states?
That again is in a gray area of our country. Gambling is not per se illegal in every state of our country, but by and large it has been held to be unlawful, illegal. There is Public Gambling Act. So gambling falls within the state list. It falls in list 2. So every state gets to decide whether it legalizes, regulates gambling or not. Sikkim, for example, Goa, these are some states that have regulated, that have legalized gambling and betting. But by and large, what the courts have held, they have segregated, they have differentiated between game of skill and game of chance. Game of skill is more or less has a legal backing. It is allowed, it is permissible. And game of chance has been discouraged and has not really received a strong legal backing yet. These rules, they talk about online games and they talk about online real money games. When the draft rules were released for public consultation, they only talked about online games which were permissible, and it was in the notified version that they actually segregated and differentiated between online games and online real money games. Now, the obligations of the intermediaries are voluminous when it comes to online real money games. Now, online real money games have also been said to be the permissible online real money games. One mischief or one interesting part that has been devised by the ministry in these particular rules is that the intermediaries generally are not supposed to create the content that goes on their websites or on their platforms, right? They're just providing access to general public to the content that is being published or uploaded by somebody else on their platform, for example Instagram, for example Facebook, etc. So there is a major distinction between a publisher and an intermediary. When we talk about online gaming intermediaries, these online gaming companies are responsible for the content of the online game as well, that they're providing access to the general public on their websites. So there is some bit of a discrepancy between how exactly these online gaming companies have been classified as intermediaries. So there was one interview of the minister of Mighty when he said that because we wanted to regulate the gaming industry, we could do that only through bringing them under the umbrella of intermediaries. So we brought them under the umbrella of intermediaries. It talks about permissible online real money game, permissible by the self-regulating bodies. Self-regulatory bodies will have to be registered with the government, and these self-regulatory bodies are largely online gaming companies which are registered as section 8 company, which have some expertise, and there are a number of conditions that are given in the rules that talk about who can be a self-regulatory body. So the self-regulatory body will then decide whether this particular online game is permissible or not. Online games that do not involve money are by and large permissible unless they are harmful to the users, they are harmful to the children, and in which case this information has to be clearly provided to the user, that this can create this harm or this can become addictive or you can have. So basically a disclaimer has to be given to the end user. Now, what becomes permissible and what becomes impermissible is when it comes to online real money games, where a significant amount is not a significant, any amount, cash or kind, is invested, is deposited by the end user, and they are expecting to win a certain amount. And that becomes the online real money game. That is how it has been defined, but there is no specific differentiation in the rules between the game of skill and game of chance. There is a gray area when it talks about it being permissible. It should not include wagering or betting or gambling, but it doesn't talk about the states which have already legalized or regularized gambling or betting or online wagering. So what happens in those situations, that has not been clarified. Then these online real money games will also have to undergo the KYC procedure that has been directed by the RBI for regular account holders. They also have to be obligated by the KYC procedure. So a person who is just trying out a game, for them to go through the whole KYC procedure and everything might also be a problem. And they don't talk about games which would require you to stake a certain amount on a game of skill. Let's say it's a fantasy sports game, it's a cricket game, and you're depositing a certain amount to then decide whether your team will win or not. If your team wins, then you get a certain amount as winning. So it doesn't talk about what happens to those kinds of games as well, but it brings online games, online gaming companies within the definition of online gaming intermediaries with certain obligations, and they have to. It also helps in the GST differentiation between game of skill and game of chance, where they say that online real money games should not be about betting or gambling or wagering. That means they are by and large going for game of skill, and game of skill has lesser GST as compared to game of chance, which has a higher GST, and there's a lot of litigation going around in that aspect as well. But it's quite interesting, and I think more clarity will come only once these online gaming companies start familiarizing themselves with the rules and regulations, and there's more interaction between the between the self-regulatory bodies and the companies that are governed by it. And then, of course, there'll be new challenges and new disputes. But right now, it's a very nascent stage to be predicting anything that may or may not happen.
That's really interesting. Now, you were talking about the fantasy sports companies. Now, what they do, like they define the services as online games rather than online real money games. So, do you think these rules will tackle those companies?
Right. So these rules have clearly categorically defined online real money games. So if there's any money involved, and they've also said cash or kind. So I believe that maybe eventually they're making room for regulation of bitcoins and cryptocurrency as well, and that's why there is not just cash, there's also kind. So if there's any kind of money involved, it will be an online real money game. So if it's a fantasy sports game, if it's Dream 11, if it is asking for a deposit, if it is giving away prizes or winnings that are made up of money, that comprise of money, then definitely it will be online real money game. So however they name themselves will not really make a difference, because at the end of the day, all of them have to be verified and checked by the self-regulatory bodies, and they have to be permissible by these self-regulatory bodies. So they'll also have those verification ticks now, and they'll have to get some certification that no bots are being used, and that a random generated certification has to be arranged by them from the self-regulatory bodies. And there also has to be an assurance that they are abiding by the extant rules and regulations and laws, and that people who are the end users of those games are competent to enter into contract, which puts a very big question mark on children engaging themselves in these kinds of games. And so online real money games are very heavily regulated. Online games which do not involve any sort of investment or deposit or winnings, they are not very heavily regulated.
That was really interesting. Now, I'm coming to the end of the section. Now, what do you think could be done better with these rules to regulate the online intermediaries?
So it's a very welcome step to begin with, having discussions about banning these online games, to finally understanding the value that it brings to our economy, and the growth that it has shown. The online gaming industry is growing rapidly, as we discussed earlier, and there's always going to be something that could be improved. And for that, we have our courts, and we have judicial interpretations, and we have amendments that are being undertaken on a daily basis by the government. And because we live in a democratic country, we have the option to object to whatever we think, or to introduce, or to suggest anything that we think would make it better, like we just discussed. Because there is not a lot of clarity on the differentiation between game of skill and game of chance, and there are ambiguities in the gambling laws of our country by and large, because of gambling being part of list 2 of our constitution. Going to be certain challenges when it comes to online gaming industry being regulated one way or another. Secondly, because online games also do not find mention in the parent act, which is IT 2000. So for subordinate legislation to be devising rules pertaining to online games might also face certain legal challenges eventually. The KYC procedure can be a little tricky, we just discussed, for people who just want to play. who just want to deposit certain money and then expect to win big. For them to go through the whole KYC procedure, although it is important, it is necessary to enhance transparency and accountability when it comes to these games. It is important, but it might be a little tricky to begin with. Then, for these self regulatory bodies to actually work independently, to be established and to be competent and to be working efficiently, that is something that only time will tell. So there is always going to be room for improvement, but it's a very welcome move to begin with.
Thank you so much for this wonderful session. It was indeed helpful for our audience in understanding these rules better. If our audience have any comments or doubts, please let us know in the comment section, or you can contact Sanya via profile link in the description box. Follow us for more such sessions in the future. Thank you, goodbye, and take care.